Do we have anything more? CTD, or are we done for the day?
I think you all are done for today.
Okay, I'm gonna sign off then.
All right, thank you.
Bye, Judge. Have a good weekend.
Bye-bye. You too. All right. The court is going to call 2021 CR 1783, State of Texas versus Kendall Blunt. Could I have parties announced for the record for the state?
Raymond Martin.
For the defense?
Raymond Martinez.
And are you Mr. Blunt? Could you unmute for me, please?
Yes,
Are
Your
you?
Honor.
All right, Mr. Blunt. This hearing started on the 13th, is my understanding. Is that correct, State?
I'm sorry, Judge?
This hearing began on the 13th?
Yes, the 13th. I thought you said the 19th, but yeah.
And that would be February 13th. At that time, the hearing was heard by
January 13th.
January 13th?
Yes.
Right. At that time, the hearing was began by Zoom because of the pandemic. And we are continuing by Zoom because of the pandemic. Any objections from the state?
No objection.
Any objections from the defense?
No, Your Honor.
Mr. Blunt, do you have any objections to this hearing taking place by Zoom?
No, Your Honor.
And for the record, at that time, the defendant's case was not indicted. And so the CM number was 079332. And that's the cause number in which the defense filed the motion to reduce bond. It's the court's understanding that CM 079332 is the same cause as the 2021 CR 1783 cause number. Is that correct?
Yes.
Yes, Your Honor.
And where we left off on January 13th is Mr. Blunt testified to his ability or inability to make bond. And after that, I believe the defense passed the witness and the state had no questions for Mr. Blunt. Is that correct?
No, I crossed him on some issues. Specifically, from my recollection, his ties to San Antonio, and that he had just moved here, I believe, from Katy, Texas. His employment was as a long-haul truck driver. His family was predominantly in, I think, the Jacksonville, Florida area, with no immediate family in the Bexar County area.
All right. Defense, did you want to follow up with any other questions for your client?
I would, Judge, and I apologize if some of these are repetitive. I'll be brief. Mr. Blunt, let's start with the last issue that the state raised. Do you have any immediate family in San Antonio?
I have a friend, a god brother that lives in San Antonio, stationed at Fort Sam Houston.
Okay. And so if you were to post bond, you understand you have a GPS condition, correct?
Yes, sir.
Has he offered to allow you to stay in his home in San Antonio if you were granted bond?
Yes, sir.
Okay. On the issue of your employment, you have worked as a long haul truck driver in the past, is that right?
Yes, sir.
Okay. But at the time of your arrest in this case, where were you working?
Niagara, over in Seguin.
Okay. And what were you doing at that company?
Yard jockey.
Okay. And for those who don't know, that's just moving the big trucks or the big trailers around the yard.
Yes, from the staging yard to the docking area, back to the staging yard.
Okay. So it requires somebody with your ability to drive a big truck, but you don't go off the property. Is that right?
Yes, sir.
Okay. And how long did you have that job?
About 3 to 4 months at the time.
Okay. Do you anticipate that there's a possibility if you were to make bond that you might still have that job?
Yes.
Okay. And so you would not have to leave Bexar County to engage in that employment?
No, I would not.
Okay. As to your prior criminal history, Mr. Blunt, have you ever been arrested anywhere for any type of an offense?
No.
This is it?
This is it.
Okay. And you have prior military service, is that correct?
Correct.
When were you discharged from the military?
June 2012.
Okay, and that was an honorable discharge?
Other than honorable.
Okay,
It's a general discharge.
okay. Judge, as I stated earlier, I'd ask the court to take judicial notice of the indictment in this case. And I don't know if you saw the motion from the state. I know you weren't going to take it up today, but I just wanted to be in the record that the state filed a motion to quash a subpoena that I sent to the medical examiner's office in regards to this same offense. One of the reasons we had recessed the hearing, Judge, was I wanted time to get the autopsy report and or medical records on the issue of cause of death. It appears those are still not available. And if the state concedes that we don't have an autopsy report, I don't think we need to talk about it much more than that.
All right, well, state, is there an autopsy report that's been completed?
The autopsy report itself has not been finalized, but there is a cause and manner of death certificate that has been completed, detailing the manner or cause and manner of death.
All right, and defense, is that what you're requesting?
That's what I had asked for, Judge, but I know now from the motion to quash that they filed, and I did know that they had already had some opinions about the manner of death, so I'm going to let that sit there. I don't have anything further to add on that issue.
All right, when you say let it sit there, are you
I'm not
don't
gonna-
want the,
I'm not going to ask the court to reconvene at some date in the future when their autopsy report is completed. Although I would reserve the right to refile my motion if I learn something when it does come out that's different than what I'm expecting, because I don't know what it's going to say until I read it. But I don't want this hearing to be delayed because we don't have that. And one last thing, Judge, I do have a discovery motion also on file on that same issue. And again, because I know that it's not been prepared, I'm not expecting the state to produce it.
okay. And then defense, of course, anytime you want a motion heard, if you'll just let the court coordinator know, we will set it for you.
And so, Judge, I have no further evidence to offer on the motion, Judge, just argument.
All right, state?
I have a couple of questions for Mr. Blunt on what he said just recently in this hearing today.
All right.
And I'm not claiming that you're not being truthful, but you do realize that Seguin is not in Bexar County, right? It's in Guadalupe County.
I did not know.
Okay. And what were the circumstances of your general discharge?
Circumstances?
Yeah.
What do you exactly mean?
What happened? Did you voluntarily leave? Were you asked to leave?
It was an issue with my transfer paperwork, which caused my discharge.
What was that issue?
I transferred from the reserve to the National Guard, and my commander signed in the wrong spot, and they did not forward my paperwork up above him for it to be signed, so they just discharged me.
That couldn't be clarified in any manner?
What do you mean clarified?
The issue with the paperwork? I mean, instead of fixing the issue with the paperwork to allow you to stay in the National Guard, they just said, no, have a nice day.
Pretty much, because the commander who previously had signed it, it was a change of command. So a new commander took his place and he didn't want to deal with it.
He just didn't want to sign it.
Pretty much.
Okay. That's all I have here.
All right. Any further questions from the defense?
No, Your Honor.
All right, defense, call your next witness.
We have no further witnesses, Judge.
All right, state.
Just real briefly, we do have Robert Green with the Civil Division here on that motion to quash, and a representative from the ME's office kind of on standby. Can we let them both go, Ray?
I think so, Judge. I'm not going to address that any further than what I've already done.
All right. Then you're both excused. Anyone who's here from the medical examiner's office, and Mr. Green, you're excused.
Thank you, Your Honor.
Thank you. All right, then, state, any witnesses?
No witnesses, Judge. I do offer State's Exhibit number 1, which was emailed to the court reporter, and Mr. Martinez earlier. It is essentially the report from the lead detective, Detective Mulder with Converse PD.
All right, and for the record, the court has received the email, but the court has not opened the email to see the contents of the State's Exhibit 1. Is there any objection to State's Exhibit number 1?
No objection to the court using it for purposes of this hearing, Judge.
All right, then State's Exhibit number 1 is admitted for purposes of this hearing. And let me review it. Just give me a moment, everyone.
groups that you're friends in, like that's a good one for your area.
Where is that coming from?
Judge, I'm back from the breakout room.
We're in the middle of hearing. Just give me a moment.
I'm sorry, Judge.
No problem. Okay. I reviewed state's exhibit number 1. State, any other evidence?
No, rest. Sorry, I'm working on 3 monitors and I have my number 1 monitor swapped with another, so I can't ever find my mouse.
Okay. All right. Defense, do you close?
We do, Judge.
State, do you close?
We're close.
All right, defense, court will hear argument. It's your motion.
Judge, I'd like to begin by citing to the court a case out of the Fourth Court of Appeals, Ex parte Gabriel Bernal. The memorandum of opinion number is 0404000100-CR. That's an unpublished opinion, Your Honor, from 2004. And I know the court has already been apprised of this case, but to make my record, I just wanted to refer to it.
Yes.
And in that case, the Fourth Court basically talks about the different issues surrounding a bail amount. And I think we've addressed them in this hearing. The bail should not be so high as to be oppressive. The court is allowed to consider the circumstances of the case, as well as the ability to make the bail, future safety of the victim, the defendant's prior work record, ties to the community, prior criminal record, and any other circumstances, aggravating or otherwise, that are relevant. Judge, in the Gabriel Bernal case, that defendant was charged with 2 capital murders, case that happened in Medina County. His bond was originally set at $750,000 for each one. A particularly violent offense where there was an allegation that he had shot 2 people 30 times. In a bond reduction hearing, the trial court in Medina County set his bond at $325,000 for each capital murder. That was appealed by the state, and the Fourth Court found that based on all those factors that I detailed and they recite in the case, that in fact the reduction to 325 was not an abuse of discretion by the court in that case. And I think this case is relevant to ours in the sense that it's also a murder, although it's not a capital. And if you look at all the factors, I think, and look at what the amount was that was set there, there's certainly room for this court to reduce this bond and still be in compliance with the purposes of a bond. And so with that, Judge, we're asking the court to consider a $150,000 bond on this murder charge. I also asked the court to take judicial notice of the indictment because it appears the grand jury came to the conclusion that there's multiple situations at play in this case, and there could be multiple different theories about what actually occurred in this situation. And so clearly that's going to be the point of contention in the trial if we get there at some point in the future as to what actually happened and what was really truly the cause of death in this case. And so again, Judge, we'd ask for $150,000 bond.
All right, state.
We're going to ask the court to keep the bond and all conditions where they are. As for the indictment, there is a 3-paragraph indictment, 3-paragraph count alleging 3 different ways of committing the offense of murder. I actually did the indictment and put a count 2 of aggravated assault causing serious bodily injury to a family member, mainly for potential use down the road. It's the state's position that once the autopsy report is finalized, that if in a jury trial, that count will essentially be waived, and we will proceed on the murder count. As to the case that the defense has cited, one of the things to be considered is the nature of the offense and the circumstances under which they were committed. And in State's Exhibit number 1, Detective Mulder details kind of from multiple witnesses and people involved, the injuries sustained by the victim were caused by 4 or 5 loud thud sounds, we believe, according to the victim's juvenile daughter, who was in the house at the time, rendering the victim brain dead to the point she eventually passed away. That the victim suffered a violent death, and the defendant fled the scene, and not only fled the scene, but tried to garner the assistance of a friend of his to come back and get his vehicle so that he could have it and probably flee the entire area and head back to Florida is kind of our assumption. There's also the safety, future safety of the victim and the community. In State's Exhibit 1, there are 2 different instances. One, a voicemail that was left by the defendant, and another, an email purported to be from the defendant, both outlining the potential for violence against the victim and the family.
Judge, we have to object to that as it wasn't admitted into evidence because we have.
Exhibit number 1 is, and on page 8, talking with a Mr. Dean, talks about the nature of the email he recalls was the defendant threatening the victim with violence over a dog or cat or dog or a car or something in the house. On page 10, referring to the voicemail, it's a voice recording of the defendant threatening to kill the victim and her children, talking about gunning people down and going over and murdering all of them. Also, the nature of the offense that happened, according to the juvenile daughter who was in the house, when she tried to call the police, the defendant threatened her that if she called the police, he would burn the house down with her mother in it. He has very minimal ties, I will put it at that, to another, I think he called him a god brother who lives here that says he can live with him. If he'll enlist the assistance of a friend to help him get away, what would keep him from enlisting his god brother to help him get away and flee these very serious charges to hopefully flee from justice? Mr. Martinez referenced the ex parte Gabriel Bernal case as being a particularly violent offense. That would involve shooting the victims, I believe, close to 30 times, if not somewhere around there. In that case, I don't see how beating somebody to death, causing them to become brain dead, is any less violent than that. So we would ask all the conditions remain the same. The bond remained what it is, full GPS, with should he make a bond that it's set at, that he not leave Bear County at all. Also, I know there's no contact with, I believe, you can look real quick, with the victim's family. We would ask that that continue. And also that it's not in this one, but that the defendant be prohibited from possessing any sort of firearms, as there were multiple firearms recovered from his vehicle that was left at the scene.
All right, defense is your motion, so I'll give you the last word.
Judge, not to belabor the point, when I objected to the audio of that voicemail, I think that in all fairness to Mr. Blunt, the detectives were advised that that voicemail was not in time related to this incident. It was a voicemail from years before. But that was the purpose of the objection, Judge. I just want to make sure the court didn't have some feeling that there was a voicemail left right around the time of
Yeah,
this.
and what I'll say to both parties, it took me a while because I read the entirety of State's Exhibit number 1. So I'll note what you're saying, Mr. Martinez.
Okay, Judge. That's all I have, Judge.
All right, the court will deny the motion. If you are released, however, you will be subject to full GPS. You're to reside in Bexar County, and there's to be no firearm or ammunition possession. If there's nothing else, the record will be closed.
Nothing from the state, Judge.
All right, he has been indicted, so he should have a court date coming up soon. Norman, do you know in the system, has there been a court date set for this case, please?
Let me double check that.
April 1st.
Sorry. All
April
right, so April 1st?
Yes, ma'am.
All right, so Mr. Blunt will be back on April 1st.
And Judge, just one last thing. Can we take up the motion at that time, the discovery?
Yes, just let the state know, give them notice what motion you want heard, and the court will hear it. And so state, he's saying he wants to have a hearing on a motion to discover.
It's the same issue, Judge. It's just the autopsy report.
Yeah, is it the autopsy report?
Yes.
And the ME's office knows that we're waiting for it. Detective Mulder's been really good about forwarding me everything as soon as she gets it. So my hope is we'll have it by then. And as soon as I know that we have it, I'll make sure one that it's uploaded to the e-discovery, but I'll email Mr. Martinez a copy separately also.
All right,
Oh, we have-
okay. All right, thank you. Do you need to speak with Mr. Blunt anymore, Mr. Martinez and Ms. Cruz?
I might as well take advantage since he's here, Judge. Yes.
All right, and after you finish speaking with him, if you'll come back and bring him back to the main room so we can release him from here.
Yes, Your Honor.
All right, I'll send you all to breakout room number 2. Mr. Ramirez, you said you were back from the breakout room?
Ma'am?
No, Judge, that was Chris Simpkins who said that.
Oh, Chris Simpkins, you're back?
Yes, I was in there with him.
Yes.
Okay, what is happening with your client?
I do not believe she wishes to accept the plea bargain. We have had some discovery issues we've been discussing, and that's where we are, Judge.
What discovery issues?
There are images in this case, and as of right now, the only copies are screenshots or printouts that aren't digital or enhanced. And I'm just trying to
I'm
ask.
sorry, you're fading off on me. You're going down like this. Could you keep your voice up like this so I can hear what you're saying? And he's frozen in time. Mr. Ramirez, what issues are there?
He's asking for digital copies of the images in question. I reached out to the complainants. This case is not recent, so they have informed me that they're unaware if they still have digital copies of those. They believe they gave them to the detective. I've let Mr. Simpkins know that he's had everything that I've been provided. If at some point in the future, digital images come into my possession or the state's possession, they will obviously be passed on to him.
All right, so who has these digital images? First of all, do the digital images exist?
I can't say 100%, Judge. That's
right.
why I don't know what I don't have.
Who would have these images?
Either the detective or the complainants, and I've both been reassured that I've been given everything.
All right, Norma, reset this. And it's going to be a hearing on discovery, and I'm going to want an acknowledgement of discovery done. If there are some issues with discovery, defense, subpoena, whomever you want to subpoena, we'll have them come to court and we'll find if there are digital images.
I believe the phone's in there.
I'm sorry, what?
He said he believes the phone's in
The phone-
the police department's possession. I'm not sure that's still the case because when I spoke to the complainants, they had possession of the phones, but they weren't aware if they still worked or if the images were still on those phones when I spoke to them recently.
All right, Norma, recall this for discovery.
April 9th.
All right, thank you, Judge. May I be excused?
No, just 1 second. So
Okay.
discovery is going to be April 9th at 9 a.m. And
the defendant-
yes. And whoever you need to subpoena needs to be subpoenaed for that hearing because we're not coming back for a discovery issue. This case is an old case. So discovery issues will be settled on April 9th by hearing or whatever you all choose to do. But I'm going to want an acknowledgement of discovery signed on April 9th.
All right, Judge.
So see you then. And Miss Deborah Lawn, if you have any more issues about your time and the quality of your time, as though your time is more valuable than anyone else's, you can come to the courtroom.
I did. I will.
Oh, okay. Let's do this.
I have.
Norma,
And
Norma, put this on an in-person day.
yes, please. I
Yes,
appreciate
we will.
that.
Yeah, we
Thank
will.
you.
Norma, put this on an in-person day. What day is that?
That would be April the 7th, Judge.
All right, we're going to be here on April 7th. Ms.
Thank you.
Lund, you will no longer be allowed to appear by video. You'll have to appear in courtroom. It's the 187 District Court, 300 De La Rosa, 4th floor. See you
I
then.
appreciate that. Thank you.
You're welcome. All
May I be-
right. Yes. So, Mr. Simpkins, just know that your client must always appear in court. She will no longer be allowed to appear by video.
I will advise her of that, Judge.
All right. Thank you. Have a great day.
And Judge, as far as the attorneys, are we still able to appear via Zoom?
Yes.
Okay. And I apologize, Judge. I know this case was set on Wednesday. I think it got recalled to today, and I actually had shoulder surgery yesterday. So I just got the recall, I guess, this morning when I checked my emails.
What kind of shoulder surgery was this?
So I have a torn labrum. So they did a bicep tenodesis where they cut the bicep where it connects to the shoulder and reattached it to my humerus. So
Well, that's very funny.
yeah, that's where I was yesterday. So
You see my play on words there, David and Brenna. I was just going to ask you, is this was a shoulder surgery that if a woman had it, she would just be fine and be able to come in like right after it was over?
I don't think so, but my wife who's doing about a month would probably beg to differ and say she would be there that same day.
See, I'm telling you. All right, but thank you for coming in. I hope your shoulder gets better. Be sure to do your rehab.
Well, I'll see you on the 9th, Judge.
All right,
Or I guess the
no.
7th.
The 7th.
Okay.
All right, thank you. Bye-bye.
Yeah.
I'm gonna peace out to lunch now.
All right, thank you. We just have one more. We have Carlos Ramirez, and that is an assault family choking.
Oh, man.
So I'm going to send you to a breakout room with his attorney, breakout room number 1.
Is it 9 o'clock already, Judge?
Hi, guys, we're back. What is happening with Mr. Blunt? Is he excused?
He's excused, Judge, yes.
All right, thank you. Norma, can you let them know that Mr. Blunt can go back?
Yes.
All right, thank you. Good weekend, Mr. Blunt.
You too, Your Honor.
All right, thank you.
You're welcome.
All right, everyone. Actually, I think we are done for today. So I think I'm going to stop live stream. Hopefully everyone will have a good weekend, a safe weekend, wear your mask.